Professor Dr. P.T. Saxena ma'am, Registrar Sir, office bearers, respected teaching and non-teaching staff, and dear students. I, Dr. Sarita, Chairperson, Student Enrichment Cell, HPNLU Shimla, extends my warm welcome to all. Today we gather to celebrate our 9th Foundation Day, a day that reminds us of the very roots of this institution. This day is not just a date in the calendar, it's a living reminder of the hard work, dedication, and faith of all those who built this university brick by brick, idea by idea, and dream by dream. Today, as we gather here to celebrate this occasion, it gives me immense pleasure and deep honor to stand before you and acknowledge the extraordinary contribution of our founding Vice Chancellor, Professor Dr. S.T. Raina. So, it was under your pioneering guidance that this university first saw the light of day. You did not merely lay bricks and walls, but sowed the seed of vision, spirit, and culture of learning. From the very first day, your dedication, foresight, and perseverance have been the guiding stars of this institution, shaping into a temple of knowledge admired far and wide. Your tireless efforts, your ability to inspire, and your unwavering commitment to nurturing both faculty and students have left a mark that time can't erase. The values of integrity, discipline, inclusiveness, and academic excellence that you instilled continue to guide us in every step we take. On behalf of entire HPNLU family, faculty, staff, and students, we offer our deepest gratitude. Your vision and leadership will forever remain the cornerstone of our journey, a light that continues to inspire us all. It's now time to commence the ceremonial proceedings of our 9th Foundation Day celebrations. I kindly invite our esteemed dignitaries for the lighting of the lamp.
There you go. Right.
Thank you, sir. It's now time to felicitate our distinguished guests. May I request BC ma'am to kindly felicitate our chief speaker for the day, Professor V. Vijay Kumar, former Vice Chancellor, NLIU Bhopal. Registrar Sir Alok. Now I request ma'am to kindly felicitate our special guest, Professor Dr. S.T. Raina, founding Vice Chancellor, HPNLU. Thank you, sir.
Yeah, teacher.
I request ma'am to kindly felicitate our guest of honor, Professor Mahavir Singh, Vice Chancellor, HPU Shimla. I also request ma'am to felicitate Mrs. Singh. Thank you, ma'am. I also acknowledge presence of Dr. Shalini Kashmiria, Assistant Professor of Law, HPU Shimla. The Kulgeet is the soul of university, reflecting its vision, values, and cultural identity. It instills a sense of pride, unity, and belonging. Let us unite our voices to celebrate the spirit, value, and pride of our institution together in singing the university Kulgeet. Thank you. I now request all dignitaries to approach the dais.
I'm nearer to the boat.
Dear all, as Professor Mahavir Singh ji has some other assignments, it's a time for signing of MOUs first. It's indeed our proud privilege to announce that Himachal Pradesh National Law University is signing Memorandum of Understanding with Himachal Pradesh University, Shimla. May I now respectfully invite our Honorable Vice Chancellor, Professor Priti Saxena Ma'am, and Honorable Vice Chancellor of HPU, Professor Mahavir Sir, to kindly sign the Memorandum of Understanding. I also request Dr. Ruchi Sapaiya, Chairperson, IQAC, to kindly come forward with the MOUs to be signed by the respective heads of both the institutions. Thank you, sir. Thank you, ma'am. Now I request Professor Mahavir Singh, Vice Chancellor, Himachal Pradesh University, Shimla, to come for address to our students.
Morning to everybody. Actually, I'm sorry that I have commitment. I have to participate in some important academic event. So I'm sorry for that. So, Honorable Vice Chancellor Ma'am, our Founder Vice Chancellor, former Vice Chancellor for Bangalore, and the Registrar, all the faculty members, dear law students. Uh, this is special moment for me to visit this place as a Vice Chancellor. This is proud moment for me that proud former Vice Chancellor Professor Rana is also here. I have long association with him. I think in 15 years before when he was Vice Chancellor here. So कहना बहुत कुछ था because of time constraint, but I want to give important message to law expert, law student. Today, world is changing so fast in the era of AI, technological changes, all different kinds of environmental issues, other business issues, global issues. So law is also very important. Legal aspects is very important. I have collaboration with legal law researcher also from different parts of country, even abroad. When I was in British Council Commonwealth Fellow in Cambridge University, I have long association with legal experts. So since my area of research is Suksham technology, that is nanotechnology, when we go from ordinary world to quantum world, in the present time, because of quantum computing and AI, these are the core area where, legal issues are also important. Why I'm talking about legal issue? Because when we go from bulk level to nano level, all the material become toxic. So this is very important. If we want to use the nano material for society, for useful purposes, then there are various legal aspects. Because material becomes sometimes toxic. So there are various challenges when we want to use these materials. Say, for example, I gave you one common example generally. On one hand, we talk about carbon. Nobody likes carbon. That is ordinary. But when we reduce the scale of carbon to Suksham level, that is nano, it becomes graphene. Dear friends, graphene is the future material. अगला जो वक्त है वो गोल्ड और डायमंड का नहीं है. It is the time of graphene. Graphene is very important. If you want to increase the strength of steel, which is we used in Volvo buses, अगर आप Volvo buses देखें, benzene की जो buses है, if we add even pinch of graphene with steel, its strength increases 1,000 times more. There is no answer before scientists why it happened so. Why there is drastic change when we go from ordinary carbon to Sukshma graphene. So there are other examples also. That is why legal aspect is also very important. So this is my message. In the era of technological era we are living, so fast transition. हमारा वक्त होता था पहले, अगर कोई प्रोडक्ट लॉन्च होता था वो 10 साल के लिए होता था. डियर फ्रेंड, आज 1 साल भी कोई प्रोडक्ट चलता तो बहुत बड़ी बात है. एवरी डे टेक्नोलॉजी इज चेंजिंग. और ये कहा गया है इस कलयुग के अंत में टेक्नोलॉजी इतनी फास्ट होगी, जब सेकंड्स में फास्ट होगी टेक्नोलॉजी, कैसे आप डिमांड और सप्लाई को कंट्रोल करोगे? दिस इज बिग इशू. अगर हर घंटे में टेक्नोलॉजी चेंज होगी तो डिमांड और सप्लाई का कैसे होगा? मूवमेंट ऑफ प्रोडक्ट कैसे होगी? सो देन लीगल इज ऑल्सो वेरी इंपॉर्टेंट. और आज की डेट में तो चाहे हेल्थ सेक्टर है, चाहे बिजनेस है, चाहे बीकॉम, बीए, बीबीए, इसमें भी लॉ का बहुत इंपॉर्टेंट एरिया है. सो दिस इज वेरी इमर्जिंग एरिया. और आने वाले समय में आई थिंक legal side, technological side, and the mixing of these two is very important. And at last I want to give one message. अगर आप जिंदगी में ग्रो करना चाहते हैं in any area, you have to be collaborative in nature. आपको कोलैबोरेट करना पड़ेगा वर्ल्ड वाइड. So this is my message. If you want to grow as an expert in legal, please have a nature of collaborative. शेयर करें जितना हो सके. कोलैबोरेटिव, डिफरेंट यूनिवर्सिटी के साथ आप कोलैबोरेट भी कर सकते हैं. एज ए स्टूडेंट भी आप कोलैबोरेट कर सकते हैं. वो चाहे यूएस है, चाहे यूरोप है, चाहे यूके है, फ्रांस है, और इंडिया के अंदर है. जितने भी लॉ के जो बड़े बड़े इंस्टीट्यूट है, आप कोलैबोरेट करिए. क्योंकि हमारे समय में कुछ और बात होती थी, बट इन द प्रेजेंट टाइम यू हैव टू बी कोलैबोरेटिव इन नेचर इफ यू वांट टू grow in a big way. So that is my message. So I wish Madam Vice Chancellor कि जो आज आप फाउंडेशन which you are celebrating this foundation day and important दो महान हस्तियां यहाँ हमारे बीच हैं, जो कि फॉर्मर वाइस चांसलर है, स्पेशली रैना साहब जिन्होंने ये पौधा लगाया है, वो आज खुद यहाँ पर्सनली है. तो ये बहुत प्राउड मोमेंट है. और इसमें मैं भाग्यशाली समझता हूँ. थैंक्स टू मैडम वाइस चांसलर एंड ऑल फैकल्टी मेंबर कि मुझे यहाँ आने का मौका दिया. और ये इस ऐतिहासिक क्षण में MOU हुआ है HPU के साथ और लॉ यूनिवर्सिटी के साथ. दिस इज ग्रेट मोमेंट फॉर मी एज ए academician. So thank you very much, ma'am. Thank you and my best wishes. Thank you.
Thank you so much, sir, for your valuable words. On this Foundation Day, how can we forget the contribution of our former registrar, Professor Dr. S.S. Chitwal? A big round of applause. Now, it's my proud privilege to invite our esteemed Chief Speaker of the Foundation Day Lecture Series, Professor V. Vijay Kumar, former Vice Chancellor, NLIU Bhopal, who will be sharing his views on judicial accountability and removal of judges, constitutional scheme and practice. Professor Kumar is a distinguished academician and researcher of national repute. With more than 37 years rich experience in higher education and research, he has served in various prestigious academic and administrative positions, contributing immensely to the advancement of knowledge and to the shaping of institutions. His scholarly work, visionary leadership, and deep commitment to the academic excellence have earned him wide recognition and respect in the academic community. We are indeed fortunate to have him with us on this special occasion. With utmost respect, I now invite our chief speaker, Professor V. Vijay Kumar, to kindly come forward and address the class.
Professor Preeti Saxena, the Vice Chancellor of this university. Professor S. Raina, the founder Vice Chancellor of this university, whose presence on this Foundation Day is also doubling the joy that we have. Professor Mahavir Singh, we just got the MOU signed and left. Professor Alok Kumar, the registrar. Professor Chantal, my learned colleagues at HPNLU, My dear students, a very good morning to everyone present here. And I also would like to extend the foundation day greetings to everyone present here, including the founding Vice Chancellor. It's a great occasion when you look back, when you started what was here, and when you see what is present today. I think it gives an entirely different picture. In fact, I was given the freedom to choose the topic of deliberation today. And I chose this topic, judicial accountability and the removal of judges of the Indian Constitution based on theory and practice. For a simple reason, there is a process that is on. Yogesh Sharma, I don't want to call him as Justice Yogesh Sharma, right, for whatever he has done. A process has been initiated. I want all the students present here to carefully look at it. When you see an article published in a newspaper or in a journal, they all give you the title impeachment of judges, whoever it is, right? And today impeachment of Justice Yogesh Sharma. Please keep this point in mind. A judge of the Supreme Court or the High Court can never be impeached under the Indian Constitution. Can never be impeached, but they can be removed. There is world of difference between impeachment and removal, because there is only one person who can be impeached under the Indian Constitution, that is the President of India. The procedure is different, the grounds are different. So you can't say, I spoke to a number of judges on one occasion when we were celebrating 50 years of our republic in 2000. There were more than 35 sitting and retired judges in Odisha, Bhubaneswar. And when I mentioned this, they were all quite surprised. The judge can also be impeached. Kya farak padta hai? They lose the office. And that shows possibly the ignorance, and they never looked into the constitution in that particular sense. So therefore, friends, I thought I will take this opportunity to highlight historically what has transpired and how this accountability could be realized under the Indian Constitution. As you all know, that there are three branches of the government. All the three of them are co-equal. Nobody is superior, nobody is inferior. And when they drafted the constitution, the question arose, because executive can be a watchman for the legislature and vice versa. Legislature can be vice guardian or watchman for the executive and the judiciary. And judiciary can also be a watchman for these two. But ultimately the question arises, who will watch the last watchman, that is the judiciary? Because there is very, very limited, control that we have under the Indian Constitution, that is in the form of removal of the judges and nothing else. Right? Therefore, who will watch them is the greatest question, and all of you doing some research in any paper, please consider this as an important area, because there is very little literature available. But you can bring comparative perspective into our understanding and do something, and I'll also try to do a couple of things, right, as I proceed. Some of the procedures in the US and the UK to drive home the point. And therefore, accountability is the watchword today. Accountability not only of the executive, not only of the legislature, but also the judiciary. I have a long history, right? The accountability is written in one form. For example, Article 13, Clause 2 categorically limits the power of the legislature. The state shall not make any law taking away or abridging the rights granted under this part, And I think it goes on, I don't want to repeat it. So therefore, the power of the legislature is limited or restricted, that they cannot violate the fundamental rights of the citizens. Now, what if they introduce, what if they pass that legislation, and what if the president signs it and it becomes a law? And that is the place the judiciary comes into picture to declare such a law as unconstitutional, right? And I think the Indian judiciary has to be praised for all the work that it has done over a period of time. Am I going so fast? Are you able to follow?
Yes, sir.
Right? Okay. So the judiciary has done a wonderful job, and many of the Western countries, including Canada and the US today, they started referring to the judicial decisions of India, right? Because there is so much of comparative perspective, so much of Indian perspective coming in, and therefore they respect the Indian judiciary to a great extent. That is one side of the story, right? And literally there is also other side. I will come to that. There is Article 124, which creates the Supreme Court, the appointment of the judges, and there are two clauses in Article 124. That is the removal of the judge, right? Under clause 4, two grounds are given, right? Misbehavior and incapacity. So far, nobody has written a thesis on misbehavior. It is worth writing a thesis, right? In France, there is a fundamental principle in droit administrative which says higher the authority, greater is the punishment, right? If somebody, take for example, the registrar, I am just taking your example, fails to supervise the subordinate properly, and it results in a negative decision. And not in India, but in France. So you can be comfortable. So the courts in France will, punish that junior, the subordinate officer, say around 1,000 rupees or 1,000 euros fine, right? And maybe some remarks in the records. But they will also find out who the supervisor is. The registrar is the supervisor. He will be asked to pay 5,000 rupees, 5,000 euros fine. 5 times more. Why? It is because when you go higher up in the ladder, you have twin obligations. Supervision is not डराने की बात नहीं है, सबसे काम करवाने की बात, right? So you have failed to train that person, and therefore he has committed the blunder and you have not corrected it. Therefore, that is the higher punishment. Now, misbehavior on the other side of the story is a nomenclature drafted from the Australian Constitution, the Commonwealth of Australia, in which they have used the same two phrases. Please refer to it: misbehavior and incapacity. For almost 18 years, I'm sorry, I made a mention about 124 clause 4. There is also one more clause, clause 5 to 124, which authorizes the parliament to make the law. And this is the constitution, wherever I go I carry. I'm not Rahul Gandhi. Right? I don't have a bigger version of the Indian constitution to worship like Modi. Right? So at least I'm very grateful to both the leaders. They are showing through all the channels that there exists something called as the Constitution of India. Right? So clause 5 authorizes the parliament to make a law. Right? When will you make the law? The constitution came into force on 26th January 1950. They have now seen what are the areas in which they are supposed to make a law, leisurely sit and appoint commissions and committees to provide every law that is necessary. They did not do it. They did not do it. And for quite some time, The judges that we had between 1950 to 1971, I'm just, 1971, I'm just putting a break there. They were all individuals with some value, right? Some caliber. And when many of the judgments went from the Madras High Court, High Court and Bombay High Court, the Supreme Court judges could not do anything, nor could they reverse the judgments of these three high courts. Today, you see, every judgment of the Supreme Court is the reversal of the Madras High Court, Bombay High Court, Kolkata High Court. Why? Because that speaks volumes about the quality. Right? Therefore, friends, I would like to just bring to your notice that there is a provision to make the law. For almost 18 years, they did not make the law. Right? And finally, they decided to make a law in 1968. It is called as Judges Inquiry Act 1968. And as per the provisions of this act, the joint parliamentary committee was to be constituted. Who will prepare the rules? They took almost 1 year, and the Judges Inquiry rules also came into existence in 1969. Now, as students of law, you should ask this question: why was this gap of 18 years or 19 years? Or if you take 1950, almost 2 decades. And why all of a sudden they made this law? I don't know whether you will be in a position to place your finger on any of the facts that have taken place. I am here to assist you to look at a judicial decision which revolutionized and limited the power of the parliament. I hope as students of law, you must have come across this 11-judge bench judgment in I.C. Golaknath versus State of Punjab in 1967. Right? The Chief Justice then was a great judge, Justice Subbarao, and his judgment, the way that is navigated, right, to overrule 2 constitution bench decisions, Shankari Prasad and Sajjan Singh. Right? Sajjan Singh was 65, and there was a division 3:2. I will not convert this into a constitutional law class. To overrule the 5-judge bench, what you required was only 7-judge bench. But you just see the developments. Justice Subbarao constituted a 11-judge bench. It is not a 7-judge bench, not a 9-judge bench, but a 11-judge bench, because he was not very sure which judge will go with him and which judge will go with the government. Right? There are few judges that do not read anything. Whatever Madam Preeti Saxena writes, I agree. My job is over. She is her pain, she sat and wrote the judgments, right? And then I concur. I agree. Finished. This is the advantage and disadvantage in when you have benches. If you are all alone, you have to sit and write. That also you don't write nowadays. I am just deviating a little to give you 2 illustrations. Where the accountability goes. A full bench of the Delhi High Court 3 years ago decided a case relating to intellectual property rights. Right? Now, as you know, the benches are constituted by the Chief Justice, and once the bench signs, seals, and delivers the judgment, the bench becomes functus officio. They cannot continue as the same bench forever. Again, they will be sent to different benches or individual judges, whatever it is. 3 days later, Hindustan Times, Times of India, they all wrote a review of this judgment, saying that 58 paragraphs from a book have been copied in the judgment. Not 1 or 2. 58 paragraphs. And what is it? It is about intellectual property.
Oh my God.
And 58 paragraphs having been copied, they have not acknowledged it. And that was the report published in the newspaper. Next day, these 3 judges constituted the same bench on their own, went back to the High Court, recalled that order formally, deleted these 58 pages, and wrote a justification saying that the research officer committed the blunder. Now, it is an eye-opener for all of us that none of the three judges had the time or interest to go through or even glance through. Forget about going through, dur ki baat hai. Even to glance through the judgment to find out that there are few paragraphs, right, which they did not. Are they accountable? I met two of them in Bhopal when they came to Judicial Academy. I did not, know about this, but the director told me that these were the judges involved in this. I spoke to them individually to find out their opinion, because if they are together, they will give the same reason. And both of them gave the same reason. What is that? The court has the implied power to do anything it wants. Implied power. See, what a beautiful escape route, right? Can you make them accountable? Can the Chief Justice of the High Court or the Chief Justice of India, who is now speaking much about the internal rules and regulations, right, given the notice and question them, at least the other judges will be little careful in delivering the judgments. Nothing has happened. Same thing happened in the Madras High Court 3 months later, 3 years ago. There was a right to information, question asked in this division bench. They also copied around 14 paragraphs from a book, and which they did not acknowledge. And again, these two judges went back, reconstituted the bench on their own, removed those paragraphs, and shifted the blame on the researchers. So I think some of you will go as researchers to the judges, right? Be careful. Right? Don't leave your name. Now, in 1968, what happened was, when the 1967, when the Supreme Court decided this I.C. Golaknath was the state of Punjab by a 6-5 majority. Now you understand why he constituted a 11-judge bench. If it was 7, possibly you wouldn't have got that 7, right? If it was 9, still you wouldn't have got it. So it justifies, he was an intelligent judge, so he knows, he knew possibly, and therefore he constituted a much larger bench. But this is the question you should ask. If you want to overrule something, I'll once again deviate a little from the prepared note. Prepared note, I can send it across to you later, right? Sampath Kumar versus Union of India, right? The Constitution bench decided about the validity of Article 323A and 323B, right? They said it is constitutionally valid. From 1992 to 1996, 5-year period, there are at least 13 judgments which I have identified. There may be more, which I did not know. There may be more than 13 judgments, where the division benches literally overruled the 5-judge bench, blissfully ignorant about it. How are they accountable? To whom are they accountable? Are they accountable at all? Are the questions that you as youngsters should start asking, right? So far, our time is past. I think Raina will not speak about it. I will not speak about it, right? Madam May. And it is for you, youngsters, to raise by writing questions. How is it justified? Are they accountable? And more particularly, when the judges select themselves today in this country, nowhere else it is done in the world, right? And then the same judge repents that finally one judge retired because he never gave a meaningful order, very difficult to read, very difficult to understand. These are the observations. Who selected it, right? And similarly, Justice Karnan, I hope all of you must have heard about him, a unique character, right? Who even sent a warrant to sitting judges of the Supreme Court, right? So we have people of all nature, because this accountability is neither in theory nor in practice, right? Particularly after 1991, when the judges started appointing their own clan, right? And that's why you see father was Chief Justice, son has to become Chief Justice. Father was Chief Justice, the daughter has to become the first Chief Justice, right? So I think George Gadboy has written a book. If I go and speak to the judges, they will not give me the details. That fellow was a white fellow, came and went and spoke to more than 140 judges. They read out everything that they knew. And he was able to give a family tree of judges, right? Whose uncle, whose aunt, who became judges, so on and so forth. So I think in this country, accountability is the last choice. Possibly they speak about it during the last few weeks of their tenure, or last few lectures, convocation addresses that they give, right? And the Chief Justice says it is rotten, judiciary is rotten, there are more corrupt people, 10 corrupt percent, 20%, 50%, they keep on increasing the number. So therefore, friends, this one aspect, please keep this in mind. In 1967, when the judgment was delivered, very quickly I would like to mention this. Parliament has no power to amend the constitution to take away the fundamental rights granted under Part 3 of the constitution. Very simple, plain, honest words, right? Indira Gandhi, the living Machiavellian, did not understand or appreciate it. She understood, but she did not appreciate it. It is a sort of restriction on the power of the parliament. So she asked the law minister, can we remove him from office? Quickly, the law ministry huddled into research and found that they have not made the law yet. Right? Now you understand the reason why in 1968 the bill was introduced, right? And passed very quickly, and she had the majority. She could amend the constitution left, right, and the center, right? Look at 1971 24th Amendment Act. Within 5 years, the 42nd Amendment Act. 18 amendments were passed in this 6-year period. Right? She had the power to do it. Right? And then Justice Subbarao was an intelligent man. I think one among the important facets of his judgment is he used the doctrine of prospective overruling for the first time, because he knew the judgment will create havoc. All the judgments decided by the High Courts and the Supreme Court will come back if prospective overruling is not adopted. So that is the brilliance of this judge. He used it and prevented the backlog of cases coming back to the courts. That's a wonderful job. Nobody could do it, right? And he knew that the moment the bill was introduced, as a common man, we can also understand the purpose behind it. And he was the sitting Chief Justice, he understood. So slowly he started interacting with the opposition political leaders, and finally got his nomination from the opposition political parties to contest the presidential election, resigned as the Chief Justice of India, contested the presidential election. 100% he knew that he is not going to win, right? He lost the election, and in a dignified manner he went back. If he had continued, possibly he would have become the first judge or the first Chief Justice of India to have been removed from the office, which nobody would like to get into history with a negative impact. I hope you appreciate what I'm saying. From 1969, after the rules were passed, adopted by the government, there was nothing that we could do. 1971, the first earthquake. The fourth junior most judge was appointed as the Chief Justice of India, fifth in fact, superseding 4 of his senior colleagues. Hegde, Grover, Scheller, and one more, right? And all the 3 of them who were immediate senior, they left, resigned and left, and he became the Chief Justice of India. And somebody asked him the question, sir, why did you accept it? Because your seniors have been, avoided. Why did you accept it? He said, if I don't accept it, my next fellow will accept it. It was a correct answer.
A and Ray.
Right?
A and Ray, Chief Justice.
A and Ray was appointed. Now look at this. When Nixon, I'm just jumping out of the context. When President Nixon in the Watergate scandal had to remove the district judge, he had no power to remove. He can have the power to appoint the district judge. He has no power to remove. The power to remove the district judge is left with the Attorney General. So he called the Attorney General, asked him, please remove him from office. The Attorney General gave me 5 minutes. He went back to his room, his chamber, came back with an envelope, handed it over to Nixon. And Nixon opened it. It was his resignation letter. He was surprised and asked him. He said, I don't want to wash dirty linen on your behalf. I think, do you call that as leadership quality? Or do you call this as leadership quality? What if all the judges unanimously said, we will not accept to be the Chief Justice? They would have sent a very, very strong signal to the government that the judiciary is strong enough and you cannot dilute it. The moment that the dilution, somebody fourth in the order, becomes the Chief Justice, a division has been created, and I think thereafterwards it is nothing but destruction of unity and integrity of the judicial system in this country. Right from top to bottom. Whether you like it or not, this is my understanding, my appreciation of all these things. I'll just give you an example. Recently, a division bench of the Supreme Court in Tamil Nadu, state of Tamil Nadu versus governor of Tamil Nadu, said you have to sign the bill within 3 months. If you don't sign, we'll take it as deemed assent. Right? I was telling it, particularly for the youngsters, you must be a little jovial when you go and appear in the court. So if I am a lawyer in the Supreme Court when the judgment is pronounced, I would have asked the judges, sir, my client, Professor Raina, is here, and he has appealed to the court. If we don't decide within 3 months, he has every right to deem it in his favor. 3 to 6 months is the time all the 5 crore 30 lakhs cases will be disposed in no time. Application of mind is the last resort. Who will question them? Who will even challenge them? First of all, as students of law, you have to understand, please carefully read Article 145, Clause 3. If there is any constitutional interpretation is required, minimum number of judges required is 5, including a reference. And the division bench sits and decides. 3 judges sit and decide the election commissioner's appointment. I think the very judgment is not valid, right? But who will question them? The senior lawyers are all very happy because in the Supreme Court it is not the case value, it is a face value. They have established that. They are not going to question. And I think it is the younger generation who can, through the power of pen, they can highlight these things, and some researcher at least of the Supreme Court and the High Court will read, bring it to the notice of the judges, right? I think that is the only way that it can progress. Now, having said this, and I also would like to just give another link. Every one of you should read this judgment, Samsher Singh versus State of Punjab, right? Please read it once. Even if you don't understand anything, your language will improve. I am very confident your language will improve, right? Completely, it is about the removal of a district judge. I think they went all over the world, Potomac and New York, this river, that river, right? And ultimately they said, president is, right, nothing but the prime minister. Wherever you see the name president, you have to understand as prime minister. Whenever you see the right governor, you have to understand as chief minister. Why did we have the written constitution? They could have passed a resolution, we blindly follow British constitution. Right? The pain of writing 395 articles and the pain of not reading, right, is writ large in our constitutional order. So therefore, friends, that A. N. Ray was the Chief Justice in the 7-judge decision, 7-judge bench decision in Samsher Singh. And in my opinion, it was this Thanksgiving, right, for being appointed as the Chief Justice. Otherwise, he wouldn't have become the Chief Justice, right? It is the Thanksgiving judgment, number one. Number two, it was during emergency. So both of them you have to keep in mind to understand why this judgment is important today or not important today, right? Then in 1975, one more Chief Justice, M.H. Beg was appointed, superseding H.R. Khanna, right? For what? Because that habeas corpus case, right? ADM Jabalpur versus Shivkant Shukla, he was the dissenting judge. Beg was in the majority. Now, when you do all these things, when the government picks them up, based on the judgments they write in favor of the government, where is the question of accountability, right? And that accountability has drained to the greatest possible extent. And now with the Supreme Court, the collegium appointing the judges, transferring the judges, the non-existent supervisory role on the high courts. Nowhere it is given. The high court is equal to that of the Supreme Court, right? Of course, within the territory of the state. But now the Supreme Court has become a supervisory court of these high courts, which was not there, which is not there. But in practice, literally does. Because the moment the Chief Justice comes in, or any of the senior judges go to one state, you will see all the judges coming together, right? I was the registrar in the law school. The Chief Justice of India was our chancellor. So whenever the convocation, one day before we have these meetings, you will see all the High Court judges will come and sit in my office. Vijay Kumar, please introduce me. Right? They want to show their face. Now, where is it? Where is that accountability? Please, I'm putting all these things for you to raise this question on accountability. And there are lots of issues which I do not want to take much of your time. But comparatively, I would like to refer to one judgment or two judgments of the Privy Council. Now, whenever you raise a fundamental question in the Indian Constitution, the judges go to London, right? In England, it is like this, so in India, it should be there. Fundamentally, they don't understand that in England, there is no written constitution. Their traditions are more than 1,000 years old, right? And nobody even scripted them in writing, right? So it's very difficult to understand. And for everything you go back, there is something called as the Privy Council. All the 53 Commonwealth countries, which still have the loyalty, including Australia and Canada today, the final court of law is not the Supreme Court or the High Court. They also go to the Privy Council. In those days, nowadays, not many people go, right? And I would like to refer to two important Privy Council decisions. And I think it's really worth reading. You can read 10 or 15 Privy Council decisions vis-a-vis on Samsher Singh. Because the number of pages is limited to 5 to 8, 11 maximum, right? Very beautifully written. And one judgment of the Privy Council of 16th May 1912, I would like to bring to your notice. Attorney General of Ontario versus Attorney General of Canada, right? Dismissing an appeal from the Canadian Supreme Court, the Privy Council held. I just, I don't want to get into the facts and other things. You can also download it from the internet today. You're all blessed with this, right? Ask ChatGPT, it gives you in less than a few seconds, right? And then this is what the court said. In interpretation of completely self-governing constitution founded upon a written organic instrument, such as the British North America Act, that is the constitution for Canadians. And then what is to follow is very important. If the text is explicit, the text is conclusive. Right? I don't think we need Newton's law of motion to understand this. If the text is explicit, the text is conclusive, alike in what it directs and what it forbids. I think one sentence they have driven home. You idiots, why did you come to the Privy Council? Your written constitution is more than sufficient. Let the Supreme Court decide properly by reading this. Don't look into British practices. They are quite contrary. That is the precise reason you have gone and written the constitution. And you have spent close to 3 years in writing this constitution. Right? And you follow Westminster model, which is not at all suitable to us. Right? The moment you have fundamental rights part in the Indian constitution, parliamentary form of government can never exist. But still we exist, the 75 years, we keep on speaking about it. So this is one judgment. And then one more sentence. When the text is ambiguous, for example, when the words establishing two mutually exclusive jurisdictions, one wide enough to bring a particular power within either, recourse must be had to the context and scheme of the act, scheme of the constitution. Act here means the British North America Act. Again, if the text says nothing expressly, then it is not to be presumed that the constitution withholds the power altogether. Not withholds the power altogether, still you can invoke it. In 1963, another Privy Council judgment, Adakbendro versus Ankitola, it is the case from the Supreme Court of Nigeria. I would like to read the two small paragraphs from this judgment. Right? It is to tell you something about accountability, to tell something about the written constitution as well. Right? In this case, the Privy Council observed, by these words, therefore, the power of removal is at once recognized and conditioned, removal of the Prime Minister. And since the condition of the constitutional action has been reduced to the formula of these words for the purpose of written constitution, it is the construction and nothing else that must determine the issue. Right? And I would also appreciate, please look at Article 75, Clause 3. The Council of Ministers shall be collectively responsible. Clause 2 says the President appoints the Prime Minister and advise the other ministers who hold the office during the pleasure of the President. Right? Now the pleasure of the Prime Minister after some sharing is not existing. Even if he has to remove a minister, he has to seek the Prime Minister. Will you please express your view? Right? I'll just once again deviate a little to bring in another important judgment. In Madhya Pradesh, where I spent almost 5.5 years, right? The Madhya Pradesh Lokayukta Act, Lokayukta, identified on land transaction, there was so much of corruption. Lots of money has been handed over to the ministers and identified two ministers, sitting ministers, cabinet ministers of this Madhya Pradesh Council of Ministers or cabinet in whatever language. So the Lokayukta, a retired judge of the High Court, who was conducting the inquiry, wrote to the governor because the governor has to give the sanction under the provisions of the Prevention of Corruption Act. Right? I think, please remind me, I would like to once again deviate a little for the youngsters. One Chief Justice of India who was from Karnataka, he used to encourage lots of youngsters when they appear before the cases, right? On one occasion, one junior came for asking for Passover, give some more time. He never used to give Passover. He will ask that youngster to read and come within 1 hour, 2 hours, whatever time he wants or she wants, and come back, we'll take up the issue and decide. So similarly, in this case also he said, you please go and read and come back. So this fellow was little nervous, whatever time he was given, he was very happy, went back, read the file, came back, and he went on saying PC Act, PC Act. After 5 minutes, the judge intervened and said, Counsel, we have been talking about the PC Act, what does it stand for? He said, it is Protection of the Corrupt Act. And the judge said, that is the place. You misunderstood the law, the case is dismissed because we can't protect you. So you must be very careful. So these two judges have to be prosecuted for which approval, sanction has to come from the governor. The governor, because the office is so volatile, he thought why unnecessarily instead panga kyun lena hai. He wrote a nice letter to the chief minister. I have to give sanction. Will you please approve this? Within 24 hours, the reply came, no, we cannot give the sanction. The governor decided next day within 24 hours, he gave the sanction for prosecution. So immediately the case went before the Madhya Pradesh High Court. Madhya Pradesh High Court citing Samshir Singh that the governor cannot give the sanction because the Council of Ministers specifically directed him not to give the sanction. Now who will give the sanction? Only corrupt people will be in government or what? Right? Then the matter went to the Supreme Court. A constitution bench, not 7-judge. It's a 5-judge bench led by Justice Hegde, brilliant judge, right? He was never a judge in the lower court. He was directly appointed under the jurist category, right? He went through that judgment, Samshir Singh, carefully, and he picked up on only one word. Because in that judgment, they said there are few exceptions to this rule, and we are illustrating only 2 of them. And he said that please take a third illustration. And that is how he said that there is absolutely nothing wrong in this governor giving the approval to the prosecution of these 2. So like this, things have been moving on one extreme to the other. And then in Adak Badro's case, they refer to, I will just read one more sentence. Lord Bryce, the court referred to it, said that British Constitution works by a body of understandings which no writer can formulate. Whereas the Constitution of Western Nigeria is now contained in a written instrument in which it has been sought to formulate with precision the powers and duties of various agencies that it holds in balance. So, for the interpretation of those written words, don't come to us. Right? They were very, very clear. So, there are a few paragraphs, I will not get into it. Right? Before I get into the removal of judges, give you half a dozen examples and illustrations. Madam, please remind me 5 minutes before time I can conclude. There are 2 types of accountability. Right? There are Merriam-Webster, dictionary's definition, Cambridge Dictionary, which you can verify. I'm not going to read them. Right? Now, there are 2 types of accountability of the branches of government. One is provided in the form of what these branches can do and cannot do. Can do and cannot do. Right? One I have given with reference to 13 clause 2, they cannot do. Right? There is the matter. But still, through amendment, they precisely violated that when the 44th Amendment Act deleted the right to property and put it under Article 300 of the Constitution, just to prove the progress, nothing else. Right? The second one is where the Constitution prescribes the method and manner in which one branch of the government to the other is made accountable. Sometimes, when the limits of the powers of these 3 branches is not specified in the Constitution, it becomes necessary to raise the standards of accountability on ethical considerations. What is this so-called ethical consideration? All of a sudden, when law fails, you always invoke values, ethics, so on and so forth. I would like to just, I think many of you would have flown in the aircraft or some of the wonderful buses. When you have the 2 seats, there is a common handrest, right? And you go and place your hand, the next person sitting next to you nudges you. Leave me some space, right? And then the value comes into picture. When you go and sit, the person sitting next to you is a 6-footer. You don't, nudge him because you know the consequence. So there you speak about value. Value of whom? That fellow 6-footer. He should understand there is a tiny individual sitting next to him. He should give some space. There the value comes in, right? And neither we have legal restriction, now the moral restriction, right? And that is why I said, समझदार के लिए इशारा ही काफी है. That's what people say. If so, such a huge bundles of currency were burned, that is there all over the social media, am I not worried about it? One day or the other, I have to get out of the judiciary. Why not today? Right? Let the inquiry be over. If I am proved innocent, I will come back to the judiciary. Till then, I will not come. There was only one judge who did it, Justice A.M. Bhattacharya. When he was the Chief Justice of Calcutta High Court, I think he had a unique privilege. Maybe it was followed by another lady judge later. Chief Justice of Calcutta High Court and Bombay High Court. Somebody wrote a petition because the lawyers are the worst lot. When the judges do not give favorable order, you can write anything you want. They wrote something because he wrote two beautiful books. I think those books are there in the library. Hindu law and the Constitution, Muslim law and the Constitution. Please read them. Right? For which he was given a royalty of 75,000 pounds by the Oxford University Press. It was published in London, not in India. Right? One fellow wrote a petition, oh, he has taken so much of money. There is a case pending about the rental building of Oxford University Press in Bombay. Right? And then the Chief Justice of India called him. Right? He went there, gave his resignation letter, walked out. The Chief Justice of India tried to convince him to a great extent. Why are you resigning? Don't do that. But he said no. Right? Once they have said, they will watch, everything in the public. I don't want to face this. Best thing is to. He resigned and came to law school to teach 4 years. Brilliant years I had with him to interact in the classrooms. What a wonderful person he was. Right? We have lost another judicial statesperson in this politics of lack of accountability or more sensitive accountability. Right? Okay. As I come to this part of removal, right, of the judges, as I mentioned to you, incapacity has not been defined. There are many words and phrases under the Indian Constitution which have not been defined. Article 74, for example, aid and advice. I have not seen any article till date where any scholar has written anything about aid and advice. Who can aid? Who can advise? Right? President Venkatraman wrote in his book of retirement, right? I had to administer the oath of office to two ministers. One to the Minister of Shipping and Surface Transport and another law minister. And he writes, after taking the oath as the Minister of Shipping and Surface Transport, he travelled all the way from Delhi to Bombay at the expenditure of the Government of India to see the ship for the first time in his life. And he has to aid and advise the President in the discharge of his commission. What advice can he give? How many wheels are there for the ship? How many steppings are to be carried? Right? What is the pressure for each ship? No, it becomes obnoxious for us even to discuss. Right? A person who has no knowledge of this, and then he writes about the law minister who was not having a qualification in law. Right? As students of law, as you are now facing the problem, notwithstanding anything said in the foregoing provisions of X law and present provisions of this act, we don't know what we are speaking. How to comment these two, we don't know. We falter. And this fellow who knows no sense of law, and he becomes a law minister and he has to advise the president what type of law is to be made, what type of amendment to the constitution is to be made. So aid and advice, what does it mean? We have no idea. And so is misbehavior. Misbehavior has not been defined even in the Judges Inquiry Act. Incapacity, they have done a wonderful job. I can't blame them. Incapacity is medical and mental incapacity. They will give a notice, ask the judge to appear before the medical board. If he appears, based on the report, he can either allowed to continue or the removal process can continue. Right? For misbehavior, there is no definition. Right? And therefore, I try to bring in the French comparison, higher the authority, right? Please, what we are doing and what we have done through the judges' inquiry rules is converting misbehavior into a criminal charge. Proved everything beyond reasonable doubt. And that's not going to happen within a year, within 6 months, within 3 months. No, it's not going to happen. So therefore, we have to, at least some of the youngsters sitting here, I would appreciate that you take up some, theoretical discourse on what misbehavior should mean and why it is not a criminal offense to be tried as a crime, but as some misdemeanor. I'm using the term misdemeanor. Misdemeanor is some offense committed. For example, a high court judge sits in the platform, railway platform, gives a charge that the TTE has not given him a ticket, confirmed ticket. Action must be taken against him. Right? Was he right? It is a misdemeanor. Right? Now, in many foreign countries, if you visit, I have traveled to more than 45 countries, the Chief Justices also of the Supreme Court, they come by bicycle with full attire, with helmet, everything. The cycle, take the cycle into the metro, go to the office, then they change the dress and come to the court. They don't even take this official car, paraphernalia, gunman behind. Right? I think we have done so many British practices which are very brutish, in my opinion. So therefore, please, the purpose is to talk about a topic, but also sensitize some young mind sitting before me. Why don't you collectively, at least as a class or as a small group, conduct a sort of seminar? You have lots of time, right? Sit and discuss what this misbehavior is. Why can't I compare notes with other countries, right? And write a paper, a research paper, saying misbehavior should be treated not as a criminal offense, but as a misdemeanor, because we expect that much of behavior from a High Court judge and the Supreme Court judge. Right? That is the level. Right? And on the contrary, they have the Parliament also, Protection of Judges Act. Right? They have protected them so much that you just cannot take any action. I think Yashwant Singh Sharma is an example. Right? Please, if you are doing this work, I'll be too happy to associate with you. Right? At least online, I can come and then guide you and tell you what needs to be done. Right? Now, in Yashwant Verma's case, I'm just jump, but at least trying to drive home a point. When a stack of currency was burnt, the onus is on him to prove, right? He has to go to the police station because it is your honor, right? He doesn't want to go to the police station, right? The committee was constituted. He knows procedure. What is nonsense? We are talking about those stupid judges, and he knows procedure to protect them. There is also one more interesting case. You can also Google search, you will find it. Mysore resort case. Less spoken about that is better. Right? 5 judges went to a resort, followed by some of the women lawyers. Right? Somehow it came to the press. And a 3-member committee was sent from Delhi by the Chief Justice. Luckily for them, the Chief Justice of India was from Karnataka. Right? And they gave the report because they had only 30 days in the office. And the committee gave the report. And what is her name? Indra Jaising, right? The lawyer from Bombay. She filed a petition before the Chief Justice. Please make the report public. And then Chief Justice of India wrote a beautiful judgment in that case. There is nothing in the report. However, I will not make it public. Right? Only you lawyers, you can understand what it means. There is nothing in the report. However, we will not make it public. If there is nothing in the report, I will throw it on her. Please go publish it, whatever you want to do. Right? So therefore, this is one area where I would request all of you please do something concrete. Make your law school, a pioneer in some sort of research of this nature. One I made a mention about aid and advice. The other one is misbehavior. Should it be a criminal proof, or it should be just, as I told you, that the moment it is brought to your knowledge, that they must go on their own, right? And that is not happening. And there is something which I wanted to discuss. I have prepared a 15-page paper. I don't want to get into it, right? I have given you sufficient food for thought. I hope so. I will, before getting into the removal, I want to bring the internal control, right? In 1997, the Supreme Court conducted the Chief Justices Conference. All the Chief Justices assembled in Delhi, and whatever Chief Justice said, yes, no, because beyond words of Chief Justice, nothing will go. They wrote something called as Restatement of Value of Judicial Life, the non-existent one, right? The Restatement of Value of Judicial Life, right? If there was some value, these things will not happen. In 1997, they have adopted this, right? And I'm sorry. Can anyone recognize this? The four judges.
Just press statement.
Press conference.
Press conference.
Right.
Very good, very good. I'm very happy to move on. Right? For the misdemeanor behavior of the judges, right? I have that document also with me. Two specific in the restatement of values of judicial life. Initially, it was 24, reduced to 21, and then to 16. Right? If I had given one more year, they would have reduced it to 10. Right? Two important values in this I want to bring to your notice, right? And give some sort of clue to the proposed research on misbehavior. Point number 8. A judge shall not enter into a public debate, shall not enter into any public debate or express his views in public on political matters or on matters that are pending or are likely to arise for judicial determination. That is value number 8. Right? I hope one sitting judge of the Supreme Court made a mention that our Prime Minister is working very hard in making this nation number 1. Right? Next day, all the press condemned it, right? But the press would have condemned it. He got the wonderful prize. Right? What is that? The prize is that the Protection of Human Rights Act was amended. It is not the Chief Justice of India who will become the chairman. Any judge can become the chairman. And there were 4 retired Chief Justices present. And the moment he got retired, he was appointed as the chairman of the India. I'm just, giving you some facts and figures you can appreciate it. Right? And once again, the misbehavior. There is one more article which you need to read under Article 124. 124, Clause 7. Right? Please carefully read it leisurely. I'll just convey the content of Clause 7. No person who has been a judge of this court, judge of the Supreme Court, can act or plead, right? Can act or plead before anyone or any authority within the territory of India. Whereas the High Court Chief Justices can practice anywhere except in the High Court. They can go to the Supreme Court, remaining, they have more than 26 High Courts for them to practice, right? But for the Supreme Court, the moment you become a Supreme Court judge, you cannot even hold a public office thereafter. What is happening today? Uh, I have something in store for you. Do I have some time to debate a little? Right? Okay. You can also search this Google search this, you will get it. The speech of the former finance minister, who is no more, who is he? Arun Jaitley, right? Very good. Arun Jaitley on the judges. It's a discussion which went in the parliament, and even opposition leaders, former law ministers, they also appreciated his speech. There are two versions. One goes for 27 minutes, the other one for 3 minutes and 56 seconds. I will play the smallest one, 3 minutes and 44 seconds. I don't know whether you can see this. I want you to carefully follow the words of Justice Jaitley. Post-retirement jobs determine the
Retirement interests.
decisions. I'm not saying anything. Right? And what a beautiful statement. It's $1 million statement. Right? Article 124 clause 7. Can you hear?
In many principal high courts of the country, legal practice has also become very lucrative. The best are therefore not willing to become practice. I think at some stage the Honorable Law Minister will apply himself to this question. It's an institution which must have the very best. And if the best are not willing to become judges, it creates a serious problem. Two, I think we are going a bit too far now. In every legislation, in creating post-retirement avenues for them. There is a proposal you want to increase the age. Please do it. But with a condition. That almost everyone, barring a few notable honorable men who are an exception, wants a job after retirement, and we are largely creating it for them. If we don't create it, they themselves create it. Glad the Supreme Court has reviewed its verdict saying every member of the CIC must be a judge retired.
RTI may be correct.
You have a situation where what should be the fees of a college is an accounting method. Is an accounting concept. The Supreme Court by a judicial order said fees of medical colleges and engineering colleges must be fixed by retired judges. And then said in every state we've created 2 more jobs. I think this whole temptation of continuing to occupy a litigious bungalow is a very serious temptation. And therefore, please review that unless it's absolutely essential, either some of these tribunals must be subsumed into the judicial setup.
I'll not play the full. Right? I think enough damage has been already seen. Right? Now, therefore, if you don't question, and this is what is going to happen, right? They through law you don't create it, they create through judgments, so and so. The retired vice chancellor, right? I'm sorry, retired judge should also be the vice chancellor. Where the UGC says you must hold a PhD, you must be a professor for 10 years, that fellow will be only with LLB, but he will be honorable vice chancellor thereafter. right? Possible. There are close to 30 law schools here. It happened in Bihar.
For 5
It
years.
happened, first it happened in, no, not Tamil Nadu. Tamil Nadu IAS officer. Kerala. Kerala followed it. The first one was in Rajasthan.
Yes.
I'm sorry, Gujarat. Gujarat. Mathur was the, he enjoyed full term, 5 years after that. Then second was in Punjab, in Bihar. Third one is in Kerala, right? So anyhow, this is one way of looking at it and assessing this. So you have to read lot many literature to arrive at, it is not that what you see in the judgments that they are the, ultimate one, right? The second, I'm sorry, I was reading that 8th and 9th, something came and 9th one is very, very important. A judge is expected to let his judgments speak for themselves. He shall not give interview to the media. Bang on this point. He shall not give interview to the media. Yeah, that can also be taken into consideration for your research before or after. Why not we also take him in the meeting? Right? Now, what these four judges were doing? If I am the Prime Minister, at that particular point of time, I would say initiate the proceedings. Because it is the value which you have proclaimed and you have misbehaved. It is not a criminal offense. It is a restatement of values of judicial life. And when these four judges, one of them went on to become Chief Justice, and then went on to become a member of Parliament. And when he took the oath, I think many of them booed him. I don't know how they can even stand this, right? Yeah, these are all things. I will not get into it because I'm a very good critic of judges. I know lots of stories about them. I had the privilege of teaching constitutional law with the two former Chief Justices of India, Justice Venkatramaya and Justice Venkatachalaya, right? I'm sorry, Rajendra Babu. With Justice Venkatachalaya for few seminars and conferences, all the three Chief Justices. So they used to give stories after stories, right? In on one occasion when I told the Chief Justice Venkatramaya, sir, there are skeletons in the cupboard of every judge. He looked at me as if I'm saying something. He said, what blood, you're talking about skeleton? There is blood and flesh too. And he will narrate the stories. Right? Anyhow, that's, let me just quickly come to the main point. There are lot many issues. Accountability is only in the thin air. We don't even practice. We don't even have a law to tell them what it is. And what is there in the form of the restatement of values, there's no value. And then they have the in-house proceeding. And that is the point, Yashwant Verma's case. If I have committed the crime, I have to go to stand before the sub-inspector of police or a constable, explain everything in the police station. He may ask me to stand or he may not give the chair, right? Now here, the three-member committee constituted by the Chief Justice of India under the guise of in-house proceeding summons the DGP of Delhi. You please come tell us whether there is anything against this fellow. And they have to go and, right? And even that if I were the DGP, I would say, no, I will not come. It's a criminal offense. Let them come and go to my office here. I am not the person. Go to the respective jurisdictional police. He said, I will not even come before. Nobody has that authority. The entire civil service is gone. Now there is hardly anybody who can be called as a honest, value neutral civil servant in this country. So therefore, these things will go on, and now they submitted the report, and then finally what happened, right? This Yashwant Verma approached the Supreme Court. The case title is very interesting. We will not even forget it. X versus Union of India, triple X. I think one stands for the triplex rum. The other one I don't want to mention. Right? When you do all these things, what is wrong in lending your name? Right? It is reported like this. Triple X versus Union of India. Right? What a shame. Right? And it was disposed of on 27th July 2025. I'll just come to this at the time of conclusion. Let me just begin. Half a dozen cases of removal of judges. What happened and what did not happen. What did not happen is nobody was removed yet. There have been more than 8 occasions where the parliament, one of the houses, passed a resolution for the removal of these judges, but some of them did not move beyond that. Right? One or two I will also mention. The first and the foremost was Justice V. Ramasamy, right? Who was very close to you, Chief Justice of Punjab and Haryana, and went to Supreme Court. When he went to Supreme Court, he had created, if you are not honest and sincere, transparent, you create a divide within the institution where you are working. And some of the judges who did not like him for whatever he was, they gave more information to the press, more information to everyone. And it was found out that he made 2 drivers with 2 official cars of the High Court of Punjab and Haryana to be driven from Chandigarh to Coimbatore, not even Madras. Coimbatore. Coimbatore is 450 kilometers from Madras. For his daughter's wedding. For his daughter's wedding. You call this as a misbehavior or not? If you ask an elementary student, you would certainly say yes it is. But the judges don't. Right? So he traveled, he did not travel, he went by flight. He made these 2 cars, the toll, petrol, maintenance, food, accommodation, everything came to the Punjab and Haryana High Court. And like this, there are many issues. There is also one more. I want all of you to become Chief Justices, at least for something. Even if you are a Chief Justice for 6 months in any High Court, you can go and say what Rhino has created as benches and they are not good. So I will remove all of them, buy new ones, right? And when I go, I call the PWD chief engineer, assess this depreciated value. If I spend 50 lakhs on the furniture, he will say finally 3 lakhs, 4 lakhs, right? He will say 5 lakhs. When the Chief Justice looks at him like this, he says, no, sir, 4 lakhs is fine. Second time he looks, so 3 lakhs. He need not even speak. But take the entire furniture back. Like this, there are 14 charges framed against him, out of which 12 of them were proved by this committee. It is popularly called as Savant Committee report. Please, when you find time, read this Savant Committee report. If you don't get the Savant Committee report, there is a book written by Sahare, and the title is Gone at Last. Gone at Last with vengeance he has written, because nothing could go when it was due. But finally, this fellow went after retirement. That's how he put it, Gone at Last by Sahare, right? Now, the committee looked into and said out of 14 charges, 12 of them were proved. This is a criminal proof of the misconduct, not misbehavior. And I want you to carefully read this. 12 charges, right? Maybe charges can also be leading to, misdemeanor, fine. But proving those charges beyond reasonable doubt, 12 out of 14 is criminal proof of the charges. Now, next happened interesting, right? The Lok Sabha first procedure in this free India, independent republic, right? First time they have initiated a procedure to remove Justice Ramasamy, who was a sitting judge of the Supreme Court. Very interesting. 104 members, right? The Communist Party and the Congress Party, they were in opposition, right? At that point of time, they joined together, gave a request to the Speaker saying, please, we found this obnoxious, constitute a committee, and the Savant was the chairman of the committee. They submitted the report. So what happened is, On the same day, that was the last day for Lok Sabha. 5 o'clock, the Lok Sabha was to be dissolved. Right? I want you to carefully look at Article 124, Clause 4 once again. That they can be removed on these grounds in the same session, within quotes, in the same session. Now, same session means something in the legislative domain, that there are 2 sessions of the parliament. The interregnum shall not exceed more than 6 months. Parliament, I think the constitution has given everything in detail, right? And they use the term in the same session, which once again they copied from the Commonwealth of Australia Constitution, right? And now when the House is dissolved, all the motions pending and all the bills pending in the House, they lapse, right? They made Justice Ramasamy intelligent. Ramasamy approached the Supreme Court with somebody, and the matter was reported, Subcommittee on Judicial Accountability. I would like to rename it as Subcommittee on Judicial Non-Accountability, right? Versus Union of India, decided by the Supreme Court in 1991, right? He asked a wonderful question, right? Ramasamy asked a wonderful, very intelligent fellow. He asked a wonderful question. What is that? When the House is dissolved, the motion also gets automatically lapsed. So you cannot proceed against me. I think the judges maybe the grudge against him, right? Because within the court also, it is not a united court anytime. So the judges also played with words and said it is a statutory power. Judges Inquiry Act is a statutory power, but that Judges Inquiry Act is also connected to Article 124, Clause 4 and 5. That I didn't say that. And therefore, the motion has a different meaning. Motion will not lapse. And they used another logic in the Constitution. The Speaker, even if the House is dissolved, will continue as the Speaker till the next Speaker enters the House. So he has the power to constitute the committee. So they allowed the committee to be constituted. Once again, I would like to divert a little. There is a saying in English, like father, like son, right? We have to just tweak a little. Like father-in-law, so is son-in-law. The story is, no, he is asking, so is. I don't know. No, I'm talking only about judicial life, not personal life. Right? Now, Justice Ramasamy's father-in-law was Veerasamy. He was the Chief Justice of the Madras High Court. I'll just take 2 minutes to capture this anecdote. And Veerasamy, there is a judgment delivered by the Supreme Court in 1996, Veerasamy versus Union of India. I'll tell you in pith and substance what is the meaning. Veerasamy was the Chief Justice of Madras High Court. I think Independence Day was nearing. Emergency was proclaimed on internal disturbances, right? And the Lok Sabha was dissolved by the Prime Minister, Indira Gandhi, right? And one senior lawyer from the Madras High Court, he is no more, U.N.R. Rao. You will, as a student of constitutional law, you would have come across this judgment, U.N.R. Rao versus Indira Gandhi. And you don't have to remember any interesting case for the writ of quo warranto. This is the best writ, right? He asked wonderful questions. When the House is dissolved, how can she be continued as the Prime Minister? She was also a member of the House. The House is dissolved. She ceases to be a member. How can she continue as the Prime Minister? Number one. Number two, Article 75, Clause 3 says, the Council of Ministers shall be collectively responsible to the House of the People. Where is the House of the People? So during this period, they can do anything they want and get away from law, right? And 2 wonderful questions he asked, and requested the court to give a writ of, quo warranto. Indira Gandhi landed in Madras, right? And as the Prime Minister comes, every leader would like to go and meet. And a special arrangement was also made for Justice Veerasamy. And he also went and met, and they had party. And when he was about to leave, he referred to this case that there is a case pending. I would appreciate if you could dispose of this petition at the earliest. Then he got up, he sat. Don't ask me how I got all this information. And then he said, I also have a small request to Indira Gandhi. He forgot for the time being that he was talking to a living Machiavellian of the era. Very powerful lady. Right? Very powerful in every sense of the word. If anybody objected too much, bravo. That's all kuch nahi hai. Right? And she asked, what is it? My son-in-law is fully qualified and there are vacancies in the Madras High Court. I would appreciate if you get this warrant of appointment, not warrant of arrest, warrant of appointment. It's always warrant of appointment be issued in his favor. He looked at him for a second and said, okay. He could have stopped then and there. But he said, one more request. She again looked at him and asked, what is it? The warrant of appointment shall proceed before the disposal of the case. Because if we dispose of and she doesn't, he was also an intelligent man. But he forgot, much more intelligent was this lady. So she said, yes, went back, the warrant of appointment was given. Son-in-law became an honorable judge of the High Court of Madras without any honor. You and I cannot become a judge, right? Now, when he was about to hoist the flag on the premises of the High Court, 2 days before, see how efficient our Central Bureau of Investigation, right? He left home at 9 o'clock, or maybe 8:30, 8:45. His residence in Madras, Coimbatore, Rasipuram, his wife's place, his son, daughter, whoever was present, their places, all these were ransacked, right? And within 3 hours, the entire report went to Delhi, and the telex came from the president's office. He was in the court at 12:30. His personal secretary took the telex and handed it over to him in the court. And after reading it without saying even a word, he just got up and left the court. The telex was asking him to step down so that the proceedings can go on. The offense committed was the assets and liabilities are beyond the known sources of income. Right? He came out and he did not go to this High Court at all. He went before an ordinary court under Prevention of Corruption Act. One among the objection was he was an honorable High Court judge, so Prevention of Corruption Act will not apply to him. Now, how much time do you require the Supreme Court to say that it will apply or it will not apply? They took 25 years from 1971 to 1996 and finally said a judge of this High Court or a Supreme Court is also a public servant and therefore can be prosecuted and punished under Prevention of Corruption Act. Very simple. It took 26 years. Fine, I think we can understand why the tendency is more than 5 crores today. Right? So therefore, he comes from this clan, right? Now, if you apply this, 14 charges, 12 were through, you could have been taken through the Prevention of Corruption Act. But they thought sophisticated way is to remove him from office, right? The second house immediately got elected. Congress party came with a majority. You know, I could have asked the Congress party once again to pass a resolution with 105 members, but they didn't do it. The committee continued. And based on the report of the committee, 2 other cases came before the Supreme Court. Right? See, what are the tactics? Justice is delayed so that it can be denied. Right? So therefore, one is this subcommittee on judicial accountability of the Union of India. Some of the lawyers said we will not appear before Justice Ramswamy. They requested the Chief Justice not to give any judicial work to him. So sometimes he was not given. All these things, the tamashas are going side by side, right? And finally, when the matter was taken up by the House, Sarojini Ramasamy versus Union of India, that is the second case, right? Sarojini Ramasamy versus Union of India, AAR 1992, Supreme Court 2219. The judge knew, everyone knew very well the facts of the case, the law, applicable law, the Judges Inquiry Act. Judges Inquiry Act very categorically says the report by the committee shall be submitted only to the Speaker or the Chairman of Rajya Sabha or anybody officiating, not to anybody else. Sarojini Ramasamy wanted that a report, copy of the report must also be given to her so that her husband could defend himself better, right, before the process is taken up by the houses. This will answer principles of natural justice. I don't know how many times principles of natural justice must be adhered to. In the committee, they gave him copious opportunities. Right? Again, she wanted. And then finally, the Supreme Court took some time, decided and said that she is not entitled to the report. Then came another judgment by the same Supreme Court, Krishnaswamy versus Union of India in 1993. So, in the same session, has become a 5-year plan. Right, for the removal, it became a 5-year plan. 1991 to 1993, Krishnaswamy versus Union of India. Krishnaswamy was his brother-in-law. Incidentally, he was also a Congress MP. All the facts and figures are available. I have no vengeance against anyone. Right? So Krishnaswamy went to the court, and quickly the Supreme Court dismissed his petition, saying that you have no locus standi to come on behalf of Ramasamy in the removal of this charge. But being a congressman, he was able to generate interest in the Congress High Command, and they came to the conclusion that he will negotiate with his judge. He will resign, and in the vote they will not, cast their vote. They also agreed. So the Congress party, once again, these details are available online. Congress party instructed all of them to appear on the day a whip was given. Right? Everyone expected something is going to take place. On the date of voting, a oral whip was given asking them not to vote. A oral whip was given not to vote. As the Congress party did not cast their vote, the motion failed. And then, as the quid pro quo, Ramasamy had to resign. Ramasamy was asked, why don't you resign? He said, why should I resign? Now it is over. Right, again you have to start from go. So why should I resign? A few more days left behind. And he did not submit his resignation. And if you see the Supreme Court website even today, it says retire on such and such date. Now, it is better not to speak about accountability at all. Right? So I started off there. That's why I chose the topic accountability. And I don't know what accountability would mean. Right? After so much of tamasha, finally abstaining itself is mortgaging the power of the parliament to something which is not legal, not ethical. Right? The politicians do not understand the trade, and that is why they do whatever they are doing. Right? So this is one example. Second example, even more interesting, Justice Soumitra Sen. Now this is what the judges appointing judges. When Judges Soumitra Sen's name came for nomination, some of the lawyers in Calcutta High Court collected all the important material. He was an official receiver in a case. He has received crores of rupees, put it in a bank, and the interest he has not accounted for. The full amount is not recovered. How do you make him? How do you even propose his name? But some of the judges who were interested did not bother about it, forwarded his name, and the collegium also approved, and the government also passed. He became honorable judge of the Calcutta High Court. right? But still, the problem did not be solved. Again, they initiated the proceedings, questioning his authority, so on and so forth. Always in the legal fraternity, there is some group of lawyers who do not like any judge. Some lawyers who may not like any lawyer. Right? Their job is keep on poking their nose in something, and they did it. And finally, 2 charges were framed against him. First time was done by Lok Sabha. This time it was done by Rajya Sabha. Lok Sabha committed the report, right? And now it's going to the Rajya Sabha. Now I hope you understand why Vice President Dhankar resigned. Right? Now they developed something called as an unwritten convention. Right? If such a proceeding comes place, once Lok Sabha will initiate, second time Rajya Sabha will initiate, third time it will come to Lok Sabha. But the law says, if Lok Sabha, Rajya Sabha, they didn't say anything. But if both of them pass a resolution simultaneously on the same day, both of them can join together and create a joint committee. The law is clear. But still they wanted to create a convention as against the written provisions of the Judges Inquiry Act. Right? And then they constituted a committee. Right? I want you to carefully listen to this. And this committee framed 2 charges. And the 2 charges were that as the official receiver, right, he has mishandled the entire money, right? Financial irregularities is number 1. Number 2, failure to disclose such information in the discharge of his official function as a judge, right? That is a misdemeanor. It's a mischief. So both the charges were framed and both were proved by Rajya Sabha committee, right? And the report is for the first time. First report is not available on the internet. Second report is available on the internet. Entire Rajya Sabha proceeding, date-wise, everything is available. Please look into it and enlighten yourselves, right? And then, till that point of time, Soumitra Sen, I don't want to call him as Justice Soumitra Sen. Soumitra Sen was saying, I will not resign, I will not resign. Newspaper, TV channel, why should I resign, right? But once the Rajya Sabha passed the resolution on Thursday, and the speaker certified and passed, following all the procedure, passed it on to the Lok Sabha. Friday evening, around 4 o'clock, he sent a fax to Rashtrapati Bhavan. He sent a fax, not an official letter, it's a fax. And today maybe it is valid because IT is playing its role. The fax was received by the president. President was waiting with the open pen, right? Because I wanted to take this, this is how the behavior takes place. Punjab passed a bill, right? And the bill was sent to the president for his assent under Article 254, right? 24 years, not 1 or 2 days. 24 years, successive presidents did not find time to sign it. 24 years. Here, not even 24 hours. Resignation was accepted, and not only accepted, the message was sent to the Speaker, Lok Sabha. Meera Kumar, the First Lady Speaker, was also there. I think First Lady Speaker was also there from the Congress Party, right? They had fixed schedule the motion to remove Justice Soumitra Sen to be taken up as the first agenda on Monday morning. We were all eagerly glued to see the proceedings on the television, live television in those days. So she came, read out a brief. What did she say? As the president has accepted the resignation of Soumitra Sen, Justice Soumitra Sen, there is nothing that remains in this motion. The motion is dropped. Friends, I have studied this law number of times. Before coming also, once again I verified my reading. The law doesn't say that it can be dropped at any stage. for somebody has resigned. Right? Now, I want you to calculate the amount of money wasted by this Rajya Sabha and the committee thereof, right? Running to crores of rupees. Every minute the parliament or the one house spends, it is around 19 lakhs or so. I think please look into the Association for Democratic Reforms. They have calculated and given you the figures. Crores of rupees have been spent, and then finally one word, motion is dropped. Why he has resigned? And that is the place, ladies and gentlemen, I would like to rely upon legal history. Legal history, I would like to go back. There was a fellow, Warren Hastings, the first Governor General of Kolkata, of India, placed in Kolkata. And in 1982 or so, he was forced to resign because there were so many charges against him. He resigned and handed over the charge to his in charge, Governor General, went back to London. In those days, a ship. It took 4 months for him to reach the shores of London. And there was an intelligent philosopher, writer, member of parliament, Edmund Burke. And there was an act passed by the British Parliament earlier called as Impeachment Act. There they call it as impeachment of anyone, including a judge. Right? Here we don't call it. And under the act, he initiated the proceedings in the House of Commons. They took almost 6 years, and finally he was able to prove the charges against Warren Hastings. Now, please, ladies and gentlemen, now compare these two cases. Somebody was resigned 4 years down the line. They charged him and finally impeached him in the House of Commons. And then the motion went to House of Lords. House of Lords is popularly called as Oldies House, right? Old people, right? They are all appointed for life. So they are all in their 80s and possibly some of them in the 90s. And they looked at him, why at his old age to remove him from office or impeach him. For want of one vote, the motion failed. Therefore, something else comes to my mind. Whether removal is one-stop procedure or whether the other liability should also be clearly marked in that. For example, once he is removed, such a person could never become to hold any public office. Blanket prohibition. He cannot become any officer nominated by the government of any government to any public office. He cannot vote. He cannot contest in any election. Right? His pension may be stopped. Right? You can put imaginatively anything that you want, but they did not do anything. Allowed this sen to go quietly because the motion was dropped. Now, after resignation, 4 years down the line, 6 years down the line, the House of Commons impeached, and still we are saying we follow the British parliamentary practice. Are we? For good things, we don't follow. Right? For bad things, yes. Bad things are very attractive always. Right? And therefore, this fellow went. I want to add some masala into the story. The masala I would like to add is, what after Pavitra Singh also must be sitting and watching the television. Now the motion is dropped. At 11 o'clock, he sends a fax. It is only a fictitious story. It is not real. It's not real. Please don't take it or misquote me. Right? I'm just building a story. Right? That's fiction. Post resignation.
Post resignation to withdraw my resignation.
Right? Now he sends another fax to the president. I have not sent the fax. He can make the entire Ministry of Law and the office, the Secretariat of the President run from pillar to post. Or, if he had said, though I have sent the resignation, I would like to withdraw that resignation. Because in civil service rules, central government rules, you can submit the resignation. Within 31 days, you can withdraw the resignation also. But my question is, he is a judge, a civil servant, right? What would have happened? Just imagine, right? It is for you to think, because you have to construct the law accordingly, right? Okay. Let me just move to the third one. What I put is as a fiction has become a reality, right? The third judge formally to be removed was Justice P.D. Dinakaran. Was my 1 year senior in Law College Madras. I know him very well. He came as the Chief Justice of Karnataka High Court. I keep a safe distance, right, from these people. You know, you don't go and speak to them because I know you are my classmate, you are my senior. I cannot take that liberty, right? And they themselves, some of the meetings they disclose, oh, Vijay Kumar was my classmate, my senior, we have played football together, all this, they may say, but I cannot disclose. The allegations, see, I told you, this all originate from the lawyers. Some of the lawyers collected some information that he has purchased a land, 3 acres of land in Ooty. Ooty is a hill resort like Shimla. It's a hill resort, very expensive place. 3 acres of land worth around crores of rupees, more than 4 crores. Because he was a judge in the Madras High Court, he was also able to convince or coerce the sub-registrar to assess the value to 30 lakhs. Paid the stamp duty only for 30 lakhs. And he did not buy it in his name. He bought it in the name of his mother-in-law. Right? Mother-in-law was a poor retired elementary school teacher, drawing a pension of maybe around 1,000 rupees. Right? For her to invest even 32 lakhs was, and then when these people started asking questions, Dinakaran committed some more blunders. From Karnataka, any branch, I have not sent any money. So next 2 days, the press was going to each and every branch under RTI getting some information. One day they published 4 checks and drafts taken in the name of sub-registrar Ooty, and the pockets of money, 5 lakhs, 6 lakhs, went from Bangalore. Right? As these things were going on, the Chief Justice of India, Justice Balakrishnan, then transferred him from Karnataka to insignificant Sikkim High Court. There are only 3 judges. There are less than 100 cases. Even the lawyers don't want you to dispose of these 100 cases because there will be no cases left. So, a nice place he went and stayed. And see the beauty. It was at that point of time his warrant of appointment to the Supreme Court was issued by the government of India. When all these tamashas were going on, right, from Sikkim High Court Chief Justice, he was appointed as the judge of the Supreme Court. And then I think the lawyers from Madras High Court, Karnataka High Court, they all joined together, petitioned the different places. You should never be sworn in. The president also noticed. And finally, they convinced him, why don't you resign? So finally, he submitted his resignation. Almost after a week, somebody positively, told him, he sent a letter to the Ministry of Law and Justice. The civil servant has the right to withdraw the resignation. I also would like to withdraw the resignation. So the fiction in earlier case has become a reality. I'm not telling you cock and bull story. This information is available in the public domain. You can find it out, right? And finally, the law ministry consulted every legal expert. I was also one among them, right? They were running from because such a phenomenon has never happened, right? What to do? And ultimately, some of them went and convinced him not to press for that application. So he kept quiet and finally died down, right? He was, the charges leveled were 12 charges against the committee, right? Okay, anyhow, before the committee was constituted, the other episode took over and finally resigned and left. There was one interesting resolution passed by the Rajya Sabha, Justice Pardiwala, right? A judge of, not the present one, Justice Pardiwala was in the Gujarat High Court earlier. That's a Gujarat High Court. He, in one of his judgment, he made an observation. 58 years or maybe a little more after the constitution has come into force, two things are very pathetic to demand. One is Prevention of Corruption Act. Corruption is more. The other one is reservation. People are asking for reservation. I think recently Sashi Tharoor, in one of his talks, also said that my father told me, if you want to come forward, you must be a backward. Right? Something, these two statements he made. Immediately, members of Rajya Sabha, 58 of them, joined together, passed a resolution, gave it to the chairman Rajya Sabha. It was published in the newspaper. Next day, poor Pardiwala, not Justice Pardiwala, poor Pardiwala went to the court, recalled the judgment, deleted a particular observation from the judgment, and then everything fell silent. Okay. Huh? Right? This is another. The fifth one are last three cases. C.V. Nagarjuna Reddy, right? A judge of the combined Andhra High Court. He forced a subordinate judge. The High Court has the supervisory jurisdiction on all these subordinate courts. He forced one of the principal junior division civil judge, whose name is Ramakrishna Reddy, right? Both of them belong to the same caste, Reddys, right? So he asked him to remove the name of Justice Reddy's brother, whose name was referred to in a dying declaration. See the story. That the name of his brother was referred to in a dying declaration, and he wanted the name to be removed from record, which this judge, subordinate judge, refused to do. Then the senior judge somehow, finally issued an order suspending him. That fellow also went around and finally got his suspension revoked. Again, for the second time, he was suspended. And then this was the occasion when the Rajya Sabha, right, tried to remove him twice. First time, something happened. Again, second time. And second time, they also added disproportionate assets and non-declaration as per Court rule. This is restatement of values, 1997. They added that masala also. But nothing happened. He also retired from it. Then came, I don't know how to pronounce his name. Please correct me. S.K. Gangale or Ganjale, I don't know. Gangele. A judge of the Madhya Pradesh High Court, who was accused of sexual harassment by a subordinate lady judge from Gwalior, right? And then nothing happened, and she submitted a resignation, right? Then SC judge, the committee, in-house committee was constituted, right? 3 judges came. One among the judges of the Supreme Court, very interesting story. I want you to carefully follow this. Now, this committee has a tenure of 3 months, maybe extended by another 2-3 months, depending upon the circumstances. Do you think the idiots sitting in the Ministry of Law and Justice do not know about the period in which these people will be working or not? If I want to know about a judge, when he is going to retire, it is there on the internet, the website of the Supreme Court or the High Court, right? This man was appointed as the chairman of the committee, and when the committee proceedings were on, he retired. But he opined, he was very nice, that he can continue because there is no disqualification. Once you are appointed, that if you retire, you should not continue in the committee. There was no disqualification. He presented, somebody else also presented, but this time the law ministry took a very solid opinion that if you retire, you cannot continue as a member of it. So they constituted one more member, and that fellow had to be restated of the values and the facts of the case once again. I think these things continued and nothing happened out of it. And ultimately, he also retired. I think so. And the last month, if I remember right, something behind the internal procedure, right? Something must have happened. She has withdrawn the complaint. She has been posted back. Her resignation was also withdrawn, and she is posted back as a judicial officer in Madhya Pradesh. And then comes the last concluding example of Yashwant Verma. I think I have already mentioned this, so I will not waste your time. Now, the summing up is very simple. I do not know what is Mumbai accountability. So I cannot convey anything meaningful to you as to what is Mumbai accountability. Whether external or internal, both have failed in this country. Right? Neither the parliament nor this one. I don't know even Yashwant Sinha whether the parliament will take a call. I am not very sure because nobody would like to get into the annals of history being the first judge, right? Maybe after submission of the report, he may also resign or he may retire, right? New grounds will be found, right? I don't know. Somehow, somewhere, the faculty of law, the students of law, the researchers, I think we are all keeping quiet, right? You have all to rise, the students, please. You have to rise above all these things, right? In the US, there is something called as a journal published by the Harvard Law School, Harvard Law Journal, published basically by the students. The moment the journal is released, the 9 judges in black who would read them are the Supreme Court judges. To find out whether the judgment is critiqued, right, and whether the reasoning given by the author is good, they look for an opportunity to revise their judgment. Here, the judges will not read. I only hope at least the researchers will read. Thank you very much.
Thank you so much, sir, for this outstanding and thought-provoking views on judicial accountability. Truly an informative session. It's now time for a very special moment of today's program, the release of a book titled Cultural, Societal and Historical Manifestations of India, Yashpal's Fiction and Non-Fiction. This book is authored by Dr. Ruchi Raj Thakur, Faculty of English at HPNLU, is a significant contribution to the field and reflects the evolving spirit of our university. May I now humbly request our Honorable Chief Speaker, Professor V. Vijay Kumar and Professor S.C. Raina, along with our respected Vice Chancellor Ma'am and Registrar Sir, to kindly come forward for the formal release of book. I request Ruchi Ma'am to please come forward. Thank you, ma'am. Congratulations, Ruchi ma'am. Now I request our worthy registrar sir, Professor Dr. Alok Kumar, to come forward for a formal
Hello, Vice Chancellor, ma'am. Respected Chief Guest, Professor Dr. V. Vijay Kumar, sir. Our former Vice Chancellor, Professor S.C. Raina. Former Registrar, Professor S.S. Deswal. Dear colleagues, the staff members, and dearest students and their parents. On behalf of this Foundation Day week, I would like to propose vote of thanks on the occasion. First and foremost, I extend my thanks to Professor V.B.Z. Kumar sir for his enlightening inaugural address on such an important topic, that is the judicial accountability and removal of judges, constitutional esteem and practices. Sir, your words have given us much to reflect upon. Sir, your words remind me the book of Professor Upendra Bakshi, The Supreme Court and Its Politics. And many times in our LLM days, he tried to speak on these issues in Delhi University. Thank you very much, sir. A very special word of gratitude to our founder Vice Chancellor Professor S. T. Raina, whose vision and efforts laid this strong foundation upon which this university stands tall today. On this Foundation Day, we salute your vision and perseverance, sir. We also extend our sincere thanks to Vice Chancellor of Himachal Pradesh University, Professor Dr. Mahavir Singh, for gracing the ceremony and extending the solidarity and academic cooperation which has due to our institution. My heartfelt thanks to our own Vice Chancellor, Professor Dr. Priti Saxena ma'am, for inspiring guidance and support in shaping today's program. I also thank my colleagues, staff member, and students whose presence and efforts have made this Foundation Day lecture truly meaningful. Finally, I would like to thank Dr. Sarita and the entire team of the Student Enrichment Cell for finishing this whole event wonderfully. Thank you very much.
Thank you so much, Alexa. Now I request everybody to proceed for lunch. We will meet again at 2. And all the merit holders, they will seated on their respective seats. Lunch, they